Hello, everybody, and welcome to what I believe now is the eighth session in our Age of AI discussions with David Gertin, Professor Clive Holton, and myself, Ron Young. Today, we're going to talk about, or attempt to talk about, a very hot issue for some, copyright in the age of AI. Now, the first thing to say, of course, especially those who know me, I am not a lawyer. I don't pretend to be a lawyer. And basically, my interest is because what I am is a knowledge worker. And as a knowledge worker, I have been working for many, many years with copyrighted materials. And now we have new tools at our disposal, AI. And the question that we're going to discuss is, so what does copyright mean in the age of AI? So let me just briefly introduce what the copyright law is. I was looking here at a copyright fact sheet, and it said that copyright law originated in the United Kingdom from a concept of common law, the Statute of Anne in 1709. It became statutory with the passing of the Copyright Act in 1911. So it's been around for quite a while, the Copyright Act, but the current act is the Copyright Designs and Patents Act 1988. And we'll be sort of talking about the use of AI and copyright material, I guess, related to that recent act of 1988.
Can I just pause you a second, one?
Yes, David.
Presumably, I believe pretty much every country has got most countries have got their own Copyright Act, and they were all a little different.
I would imagine so. I would imagine so. I don't know for sure, but I would imagine so.
Okay.
The law, briefly, the law gives the creators of literary, dramatic, musical, artistic works, sound recordings, broadcasts, films, and typographical arrangement of published editions, the rights to control the ways in which their material may be used. And that means it talks about types of work protected are literary, dramatic, musical, artistic, typographical, sound recording, film. It also talks about when rights occur, who owns a piece of work, the duration of copyright might interest you. For literary, dramatic, musical, and artistic, it's 70 years. For sound recordings, it's 50 years. For films, it's 70 years. Typographical is 25 years, and broadcast and cable programs is 50 years. There's Crown copyright, there's parliamentary copyright, and various acts. But bringing it back to a day in the life of a knowledge worker, I've been working with copyrighted materials, as I've said, as part of the work I do and continue to do. And so I think it's important to try to understand, and I've tried to understand the fundamental principles of copyright law, but especially for me as a knowledge worker, what's called derivatives, where people are creating derivatives. So just a couple more bits, and then I'll hand over to David and Clive. What I've learned, and what I believe is the case, is the core principle really for a knowledge workers, which you may challenge, is do not directly input copyrighted material into a generative AI model for the purpose of creating new content. That's derivative. And so copyright then is legal right that protects our original work, authorship, literary, dramatic, musical, and artistic. And the danger of derivative work is a new creation that is based on one or more pre-existing works and therefore should only be for the copyright holder. So I'm going to stop there now because that surprised me. I'm not sure what the general world is doing with copyright and AI, but I hear a lot of people are spending a lot of time, like I do, reading and working with copyright material. Anyone want to pick up on that, challenge that, add to that?
Can I pick up on one point?
Yes.
Certainly, if you take a piece of copyright, copyrighted work and copy it in any way, that's infringement. So if you
Yep.
take a PDF, say, and you're going to put it into an LLM, you've got to take a copy of it to put it into the LLM. But so that's illegal. But the interesting point, I think, is once it's in there, and as long as you can't reconstitute it, in full, it is not infringement to then interact with that LLM to ask it questions of the LLM and get responses that are based on, in part at least, on that copyright material that you entered. So the onus does fall on the inputter, not on the user. Is that how you understand it?
Right. Well, I'm learning all the time myself, and I'm going to learn a lot today. But let me see if I understand what you're saying. In other words, if there is in a system some copyright material that you're interacting with, but not creating any new content, that seems to be okay to your understanding. But my question is, how does it get in there? Because most of what I read is that you should not use this, no electronic copying for any means without the permission of the copyright holder.
Now, the secondary thing is, because I think here in all of this is theory and practice. So if you agree that you've got to take a copy to enter it, let's say you're working in a large organization, and somebody has entered that material into the LLM. Maybe no one knows that it happened. Maybe nobody knows who did it. Maybe you know the person who did it, but let's just say they die.
Yeah.
What's the onus on the company? They didn't actually execute the act. So again, the more I think about it and look at it, there's some kind of quite complex nuances to all of this.
Yeah, well, I think first of all, I would like to see if I can get our understanding, and I'll come to Clive in a sec. Then perhaps we might argue that the copyright law is or is not fit for purpose in the age of AI. And what is it that we think would be? But Clive, would you like to add anything to that?
Yeah, I think the concept of copyright should continue. I am very, very interested in protecting the interests of creators. And if there's massive disruption to copyright, the people who are really going to suffer are people who currently, as creators, can get paid for their activity. And this goes beyond writers to musicians, artists, and so on. If their work can be taken in breach of copyright, they deserve to be reimbursed for that continuously and routinely. Now, what has happened, first of all, is that the LLM companies have been taking material from all over the place, and there's plenty of evidence that some of that is copyrighted material, and they've been training their LLMs on it. Now, in a just world, the creators would now be receiving license fees for their use of their materials that's been taken without their consent and over which they hold copyright. The real problem for creators at the moment are governments, because governments seem, certainly in the UK, trying to bend over backwards to anoint LLM companies who have at least partially taken copyrighted materials and are making no effort to reimburse creators. So my anxieties are at this kind of high level, as well as the more operational level that we face within organizations.
Right. I want to support your first thought on protecting the value for the creators. A reason for that is I am a content creator. And what I realized when I started to look at this in a little more detail is it made me feel even more valuable. I realized the value of the work we all as creators and content creators do. And there is a technology that can just take 1 year's work of hard research and development in a few seconds. So the plus side for me is I started to realize even more so the value of the content as a creator, which is not a bad thing. But then coming back onto the anxiety worries me as well. But where are we now? I mean, do we think, therefore, that it's just a question of enforcing the law, or do we think, just as knowledge workers, that there ought to be some review as to whether current copyright law is fit for purpose in the age of AI? Because to take your point, Clive, where certain organizations have been accused of scalping copyrighted materials, they are arguing in court what they call fair use. And my understanding is that that still is a muddy field. It's a minefield right now. And I wouldn't want to. All right, David, can you add anything?
No, I was just going to say, taking the whole document and feeding it into your LLM is not fair use.
Right.
Quoting from a document, even extracting maybe a short piece of text, maybe a little bit longer than a quote, is probably fair use. But from what I gather, fair use means different things in different jurisdictions, and it always has been a gray area. But certainly the likes of OpenAI, etc., they've been ignoring the law, basically. I mean, I think even, how to put this, even
well, allegedly, I think.
Allegedly,
Yeah.
I shouldn't.
Yeah.
Even before AI, you still had the issue that if, just take myself, that if I took, well, I found this morning that there's a website called Bookie, and on there's a whole load of books. I found Sapiens, full PDF of Sapiens, which is a very recent book by Yuval
Yes.
Harari. It's there. It seems if I read it, I'm not breaking the law. If I download it, I'm breaking the law. Now, why haven't the publishers gone after Bookie? And I Googled this morning, and it seems that one of the problems is that it can be very costly and very difficult to actually do that, especially just going back to the old music issues and things with Napster. People can move their servers around, they can change their legal names. There's all sorts of things that they can do to keep one step ahead of the publishers. So it was a difficult subject even before AI, and now it's an even bigger issue.
Yeah.
Coming on to the question of fair use, we're in the UK and we're subject to UK law. An LLM vendor who's offering services in the UK can't use Californian law to claim that that it has a more flexible definition of fair use. We've got to use the UK basis, and the UK basis is quite narrow, even for us as academics, where fair use is one of the things we can use. It's very, very limited in what you can do. So as David says, downloading scalping a whole book is certainly not under any UK laws legitimate.
Right. Okay. And Clive, you've reminded me as well of recently I was working with an aspect of the EU AI Act, which says that if I'm deploying into users, if I have an application or an offering which uses AI, which I'm deploying into users who are resident in the EU, then my content has to abide by the EU AI Act. Therefore, the copyright suggests to me goes further than just the UK, that we have to consider where our content is being deployed globally, does it not? I
And
mean,
it is global. Ron, do you know if the EU has a single consolidated copyright act?
I don't know.
Or
No,
does each country have something separate? Because it would seem
I
that
don't
maybe
know.
one first step, albeit a challenging one, would be to get a global copyright agreement, copyright and fair use, which I suspect would be almost impossible to do.
But if we focus on the UK, a single
Yes.
country, it's perfectly possible for the UK to decide what it wants to do. My anxiety in the UK situation is that the present government it seems to be bending over backwards to give in to the LLM vendors. It sees them for some reason as strategically important to the UK economy, and
Yes.
one of the unintended consequences, because I doubt that they're deliberately doing it, is to harm content creators, whether they're in academia, book writing, music, art, etc. And that is a very, very worrying development, given the dependence of the UK on these creative industries and creative activities.
But it's the usual issue, isn't it, Clive? That the argument is that if we don't do it, somebody else will, and they will get the edge on us in an AA race that's it's going to be hard to keep up anyway.
The
But
enforcement. Yes.
I would urge going back to fundamentals. We thrived for centuries on being a creative society. Do we want to intrinsically undermine that at this stage? And I would strongly argue that we don't, because
And I would agree. I would totally agree.
Yes, and my view is that most of the creatives in this country and elsewhere tend to be small independents or small companies that are not likely to go and want to fight a copyright law. But what I've been doing over the last couple of years is I've been working with a blockchain service where, as I sort of have an idea which I turn into something more tangible, I can store it as it was at that time on that date on the blockchain. That's immutable. And then as I move that into perhaps notes about what I'm doing and work in progress and developing, if I chose to, at the end of each month or the end of each quarter, put it on the blockchain, and then eventually it comes to my product or service that I'm offering. What I've then got is I've got a detailed development history, which doesn't cost me as an independent creator very much, to help me with a chain of certificates prove in a court that the progress and the ownership of my project. And I think tools like that would be helpful for the independent creatives, but I don't know that if many even know they exist either at this stage. Can I change the sorry, David, you were going to say
I'm
something.
just going to ask Clive, because, well, I think all three of us feel strongly about this, but Clive's voiced it more vociferously
Yes.
than either you or I. I mean, do you have any thoughts as to what we could, again, let's just take the UK, what could we change in the UK to give more protection for creators?
Well, the legislation going through at the moment proposes effectively that creatives have to explicitly opt in to protect the copyright that they have if they want to stop the LLM vendors.
So that's a big change because at the
That's a
moment,
huge change,
by
and the
default,
obvious
you've
thing
got
to do
copyright.
is to turn it the other way around and to say only those who've actually explicitly agreed to it can it be done to. So the norm is you do not allow LLM vendors to scalp creative works.
Yeah.
Indeed, indeed.
Sorry,
Very.
Mark.
No,
Back
no,
to you.
not at all. I should have mentioned in the beginning for any of our viewers that you can't copyright an idea, you copyright the expression of an
Exactly.
idea.
Yeah.
And that's, I think there's quite a lot of misunderstanding about copyright, where
Mhm.
people tell me often it was my idea. You can't copyright an idea. You can copyright
Yeah.
your expression.
Now, a slight aside, Ron,
Yes.
and you might know the answer to this. I thought I saw somewhere in the news recently that maybe at least one country was thinking of allowing people to copyright their bodies, their images, so that
Yes.
somebody couldn't create a false image of myself or you without our permission. That seems quite an important piece of legislation, if you like, that probably should be enacted.
A very good point. I'm glad you mentioned that. It was only yesterday that I was attending a webinar with Synthesia, so they'll be glad about this webinar because they mentioned yesterday they were addressing this and saying right from the beginning, they said they will only take or create a digital twin of a real person. And for it to be a real person, the real person has to sign a consent that I am the real person for this when that person is creating the digital twin themselves. That's a very good first step, if you like, that they are saying that we're ensuring that all usage of digital avatars are consent of the real person. That's a start.
Yeah.
That's all that I know, though. But
But of
okay,
course, it's not going to stop people doing it. That's the problem these days.
I was going to say let's just see how we should wrap. I'm conscious of time on this and
Yes, indeed.
moving forward with this. It affects us all as knowledge workers. And it isn't that new in the sense some of the things that Clive has been saying in particular, but even before generative AI, we've had AI that summarized documents for a long time. And you could argue it's the same copyright law as if you're reading huge 200-page documents that are copyrighted, you shouldn't be summarizing them because summarizing them using AI is creating a derivative, which you're not entitled to do. You can only read. Does that make sense? Because I know a lot of people out there will say, oh, really?
But I can summarize a book, can I not? Without breaking the copyright. So
Not
what's the difference
if it's
between
is the summary a derivative? Is the summary a derivative
no,
of
if
the
it's
original
okay, if
created
it's
work?
if I'm using their words, but if I am expressing it in my own words,
Oh, you can summarize
it sounds
yourself,
like a grey
create your
area
own.
to me as to what would be a derivative and what would be, a genuinely sort of semi-creative piece of work on my
The
part.
question is, and maybe we've got to leave it for others to comment on. I'd appreciate this subject. I think it's dear to a lot of people's heart. If anyone's got any questions or comments, it would be great if they would add them to this podcast on this issue, because it affects us all. Any closing thoughts from anybody on that? I think we've had I've really learned a lot from this and different aspects. But,
I do feel pessimistic in the UK context. On the other hand, we do have these artist bodies who are lobbying very actively. So although I'm pessimistic, at least in the UK, there's a movement which is trying to get this acknowledged at the highest levels.
Indeed.
And just a thought from me, I think that there's the issue with the the large AI companies, but there's a very personal issue as well. So let's take Sapiens. I know where that PDF is on the web. I could download it. That would be illegal. I could load it into Notebook LM, and then I could ask it to summarize it. I could ask it to create a video. I could ask it to create an audio podcast. I could do all those things with it. And those would be derivative works. That would be illegal as well. But for me, as an individual, the chances of any legal redress are like, who's going to know I'm doing it? It's going to be minimal.
Right.
It's going to be highly unlikely. So it then comes down to an ethical question. Should I do it? Now, the other question here for me, ethically, is I've actually got a copy of Sapiens. I've actually bought a copy. I've paid my due to the publisher and the author. Now it's still illegal, probably, but is it any more ethical, the fact that I've actually paid my due? I think that there are a lot of very personal issues around ethics here that, again, time will tell.
And I'm going to leave it there because I think
Good idea.
ethics is what it's all about. We've come back to ethics, and maybe we can have a future discussion where we dive deeper into ethical issues as well. I'd certainly enjoy
Yeah,
that.
we should do that. That's a good idea.
I can see all heads nodding. Well, thanks very much, guys, for this, and I hope it will be of value to others, especially the knowledge workers out there that are working with copyright materials and even more amazing, powerful AI tools by the day. And don't forget to put things in the comments, and we
Yep.
would love to have some interaction on this with it.
We would indeed. So, yeah.
Okay.
Thank you, Ron. Thank you, Clive.
Thank you.
Thank you both.